I think we're all getting a little bit of MCLE burnout as we head toward the July 1 waiting period. I mean, we did a program here last week with the medical seminar. I know the arbitrators and commissioners were in a program of their own late last week, so bear with me. We'll try and get you through another hour of MCLE as painlessly as possible, okay? So what we're going to do today is what we have tried to do at least once every other month, and that's to go through the Workers' Compensation Lawyers Association summaries of recent commission decisions. And so you should have gotten this particular set of decisions, I should say, in your mailbox maybe a couple of weeks or so ago. So these are the decisions that were reported in February of 2017. So we're still lagging a couple of months or 3 months behind, but we're going to try to catch up as we get through the year. And of course, the reason why we want to go through these commission decisions is not only because it gives us a better understanding as practitioners about what the commission is kind of currently thinking about some of these issues, but also because it presents a wide range of different issues, right? We're going to see cases about employer-employee relationship. We're going to see cases, of course, about arising out of. We're going to see cases about causation. So it's going to inevitably, I hope, hit a subject that you're working on right now where you can say, oh boy, I better go and read that case because it's an issue that is fresh in my mind and something that I'm trying to work through currently. And in that regard, although I didn't give them to you as part of your written materials, the cases themselves, the Workers' Compensation Commission decisions, are going to be posted on the WCLA website. So once we have them posted there, you'll be able to actually go and get the decision itself if you want to get a little more in-depth about what these decisions say. So what I've given you today are just some slides on a few of the cases that I picked out, frankly, because they're interesting to me. They may not be as interesting to you, but too bad. So, and also attached to this are the summaries that actually went out to your email box a few weeks ago. So you can have a summary of every single one of the cases, but the slides are only going to be on selected cases. One last thing that I do want to mention is about viewing these programs online. Please recall that the program will be available for credit online in the month after the program is presented live. So, for example, for this program, May 2nd, that online opportunity is going to be available from June 1 through June 30th, 2018 only. All right, so if you try to watch the May 2nd program in July, you might have fun watching it, it's just you're not going to be able to get credit for it. And that's because WCLA doesn't have the ability to kind of keep things open much longer than that because of the record keeping that we have to do on behalf of the MCLE board, okay? So please remember that watching things online, you can only do it in that 1 month period after it airs live, okay? I hope some of you have done that already online. I know that there's some technological issues still for some of us, but if you ever have a technological issue about watching things online, just email me, especially if it's a matter of getting the certificate. I can always send you the certificate, but we do need to know if you're having issues still viewing things online, okay? All right, good. All right. Any other questions about that, about WCLA MCLE? All right, good. So let's go ahead and get started with the cases. So basically, I'm going to take the cases in order in which they are presented in the summaries. All right, so if you kind of want to follow along with the slides and the summaries, you can do that at the same time. So the Beecher-Keeler versus State of Illinois Murray Center case is an important case because, once again, it talks about the arising out of issue, which seems to be an issue that's coming up time and time again, not only in front of the commission, but also in front of the appellate court. So let's take a few minutes to look at this case. Again, I think we're going to try and play the game that we maybe played last time, which is, try to identify which prong this is. Is this the arising out of prong? Is this the in the course of prong? And then maybe even in addition to that, we're going to talk about what kind of risk is this, right? We constantly talk about the three kinds of risk: personal risk, employment risk, neutral risk. Let's see if we can identify in some of these cases what kind of risk that this might be to help you analyze maybe some fact patterns that you're working on now. So Deidre Kaler was a dishwasher at the State of Illinois facility, and after washing some dishes, she was drying her hands on a paper towel, turned to throw that paper towel into the garbage can, and noticed a pop or a pain in her knee. All right? So, pretty typical kind of thing, right? A person turning around, dropping something into a garbage can, feeling a pop in her knee. In this particular case, the arbitrator denied the benefits. I think pretty clearly everybody agreed that Ms. Kaler was in the course of her employment, inside this facility, washing dishes at the time this incident occurred. So there's no kind of game playing here. This is pretty clearly an arising out of case. And I would abbreviated that by saying AOO, right? Arising out of. So this is an arising out of case. And the question becomes is, what kind of risk is that, right? What kind of risk is having a paper towel in your hand, turning to drop the paper towel into a garbage can and snapping your knee in some way, right? Injuring your knee in some way. In this particular case, the arbitrator denied benefits, right? And the arbitrator denied the benefits in two ways, right? The arbitrator said, first of all, the risk of throwing away a paper towel is not a risk distinctly associated with the employment, right? So when we hear those kinds of words, distinctly associated with the employment, what we think about is that employment risk category, right? Employment risk is a risk associated with the employment, connected with the employment, incidental to the employment, whatever kind of descriptive word you want to use. In this case, the arbitrator said that this was not an employment risk because that risk of turning and popping your knee is not a risk distinctly associated with the employment as a cook. I'm sorry, I called her a dishwasher. She was in fact a cook at the facility. And the arbitrator went on to say that if you analyze this case under the neutral risk analysis, that even under the neutral risk analysis, it was not compensable. And the reason that it's not compensable under the neutral risk analysis is because it's not a risk that is greater than the general public faces, right? So this risk of turning to drop a paper towel into the garbage can is not a risk greater than what the general public faces, and therefore is not one of those kinds of neutral risks that becomes compensable as if it were an employment-related risk, right? Because we all know that there are two kinds of neutral risk, right? There's the kind of neutral risk that can be compensable, right? And there's the kind of neutral risk that is not compensable. So the Workers' Compensation Commission affirms the arbitrator's denial of benefits, but offers a supplemental analysis, all right? So to me, it's important when the commission is telling me, right, here's a supplemental analysis for all of you lawyers out there about how we are analyzing these kinds of cases. So when the commission tells me that they're doing a supplemental analysis and not just merely affirming and adopting the arbitrator's decision, to me that seems important. So let's take a look at what might be an important analysis from the commission. So the commission, is talked about in many cases that they go on to cite here, is convinced that this is not an employment. Oops. Sorry about that. Sorry about that. So The commission is convinced that this is not an employment-related risk, right? Because the commission says that even though this activity that Ms. Taylor was engaging in, turning to drop the paper towel into the garbage after she had dried her hands with the paper towel, even though that activity was, as they say, undertaken in the furtherance of her employment duties, so they recognize that that was undertaken in furtherance of her employment duties. In my mind, that's where the analysis stops, right? But obviously, I'm wrong, okay? Because it's an everyday occurrence, right? Even though it's an everyday occurrence, or because it's an everyday occurrence, even though it is undertaken in furtherance of the employment duties, and that's a quote from the commission decision, that it is not an employment risk because it's an everyday occurrence, okay? So, one starts thinking, well, have we seen these kinds of everyday occurrences before which were employment-related risks? And we might remember a case that we talked about here a couple of weeks, sorry, it's all blurring together, a couple of years ago now, right, a case called Young, right, where Mr. Young was required to reach into a box, you know, as these boxes came down to the assembly line and remove a part. It wasn't a big heavy part, well, you know, not that. But what the appellate court said in Young was, right, that this reaching into the box, right, is something that Mr. Young had to do in order to accomplish his job, right? Kind of something like in furtherance of his employment duties, right? And even though this was a common everyday occurrence, you know, sticking your arm into a box, right, that was compensable because it related to the employment. It was something that Mr. Young had to do in order to accomplish his job. Just like I suppose Ms. Taylor argued that she had to dry her hands, right, in order to accomplish her job, right? So, but that's what the commission tells us, right? The commission says, even though it's in furtherance of the employment duties, if it's one of these everyday, quote-unquote, everyday occurrences, it cannot be considered to be distinctly associated with the employment, okay? So that's the employment risk analysis from the commission in the Taylor case. Let's look at the neutral risk analysis from the point of view of the commission, right? The arbitrator said this is not a neutral risk because it's not a risk greater than what the general public faces, and the commission agrees with that, although it also gives us this supplemental analysis by saying, don't forget that there are certain kinds of neutral risks that can be turned into employment-related risks through this qualitative or quantitative analysis, right? Qualitative meaning you have to do it a bunch of times, right, in order to accomplish your job, right? And quantitative, I'm sorry, that's quantitative. I always mix those up. Qualitative meaning that it's like an employment risk, right? And that's the part that I've never gotten a really great understanding of, because if something is a qualitatively similar to an employment risk, why isn't it just an employment risk? But in any event, those are the two different analyses that can turn a neutral risk into an employment-related risk. But, you know, the commission cites a couple of cases that turned out differently for petitioners under that kind of analysis, right? So we've already talked about the Young case. Remember the Steak and Shake case, which is a case we talked about here, an appellate court case, where the petitioner is required to clean off the table, right? And as she's cleaning off the table, kind of doing this motion, she feels a pop in her elbow, right? And the appellate court said that under those circumstances, that was an employment-related risk, right? Because she's got to make that motion in order to clean off the tables. And I suppose Ms. Taylor said, how is that different from me having to make this motion to throw away the paper towel, right? But the commission didn't buy it. Looking at it from the neutral risk point of view, right, the commission talks about the Adcock case, another appellate court case that we talked about here. Remember Adcock? This is the guy who's sitting in a chair, he's a welder, and he's got to make this turn. You know, I think the testimony in that case, or the evidence, was 70 times a day. He's got to make this turn, right? And what the appellate court said, even though that's an everyday occurrence, you know, making this turn in this swiveling chair, right, that the quantitative analysis, as it applies to a neutral risk, turns that into a compensable case, okay? So here's Mr. Adcock doing this in a chair under a quantitative neutral risk analysis, getting compensation, and Ms. Kaler doing this, right, not getting compensation. So, but it's an important case because it's the commission telling us how they're going to analyze these cases, right? They're going to look to see first if it's an employment-related risk, and then they're going to look to see if it's a neutral risk, and then do the qualitative or quantitative analysis based on that. All right? Okay. Any questions about that? Yes, sir.
No, I read in this article that there was no evidence offered that a certified food handler must wash their hands much more often than the general public.
So the question from the arbitrator is, was there any evidence about, you know, that because you're a food handler, you have to wash your hands more than the general public? So kind of the quantitative neutral risk analysis. And the answer is no, as far as I can tell, no, because as far as I can tell from this case, right, the petitioner was convinced that this was an employment-related risk, right? Absolutely convinced. Like, I've got to wash my hands in order to do my job, and part of washing my hands is throwing a paper towel away, right? And that is connected to the employment. It's incidental to the employment. Doesn't matter whether it's a common everyday activity, just like it was in Adcock and Young and Steak and Shake, right? Because it's an employment-related risk. And I suppose what she was thinking, which is what I'm usually thinking, right? There are a lot of employment risks that are just common everyday activities, right? We're going to see one in a CTA case coming up, or a bus case, I can't remember the name of it, I'll figure it out when I get there, right? Where the petitioner is reaching up to change the bus sign, right? Pretty much common everyday activity. Guess what? That case turns out to be compensable, right? So under employment, as far as I can tell, under employment risk theory, because she's got to change the bus sign by reaching up above her head and tapping this button that, you know, says this is now the, you know, number 60 route or whatever. Yes, sir. Yeah.
What about the personal comfort factor? Did that enter into this?
So John asked, what about the personal comfort doctrine, right? And I'm sure there's somebody who's got a better response out there, but my response is, personal comfort doctrine for me is an in the course of issue, right? It's an in the course of issue. There's no question she was in the course of her employment. There's no question she was in the course of her employment. So it wasn't like she was in the bathroom upstairs, you know, on her break, washing her hands, right, when she did this, right? Because that's an in the course of, I think anyway, that when I think of personal comfort, what I think of is an in the course of issue. Right? Anybody think otherwise? Good. All right, great. All right. Yes, sir.
But do you, I mean, there are appellate court cases, maybe the Supreme Court cases on this. I mean, this thing about everyday activity exceptions.
Yeah.
What's your feeling about how something like this is treated on appeal?
So, I express no personal opinions regarding that. But all I'm saying is that if you, right, but one of the cases that is cited here, right, by the commission is CISPRO, right? And the language in CISPRO is connected to the employment or incidental to the employment or a risk greater than trouble. There's ors between those things, right? And I suppose what Ms. Kaler was saying, of course washing my hands and turning to throw the paper towel away is connected to my employment. I was doing my employment at the time that this happened to me, right? So CISBRO is the ultimate everyday activity case, right? Or twice over clean, right? The ultimate everyday activity case, right? So there are some cases, even cases that we have talked about here, like Young and Adcock and Steak and Shake, that says that just because it's an everyday activity, that doesn't determine that it's not employment, that it's not an employment risk. There are plenty of everyday activities that are employment risks. I suppose at some point one could say that sawing a board is an everyday activity if you have a hobby of being a furniture maker, right? But if you saw your finger off at work, who would not say that that's not employment related, right? So almost everything you do at work is an everyday activity. I mean, if you go to work every day, it's probably an everyday activity, right? So, all right. Anything else? Okay. So, Sheriff Smith is the case that we talked about a couple of months ago, which is the case where the commission held that it was not a compensable activity or incident when the petitioner slips and falls in her employer's parking lot because it was an unnatural accumulation of ice and snow. So I'm not bringing up this case to talk about it again because, frankly, it gives me post-traumatic stress disorder. Oh, I'm sorry. That doesn't exist if you were here last week. So I'm supposed to say anxiety adjustment disorder or something. So, but in any event, the reason why I bring it up is, as far as I can tell, the circuit court has not confirmed the commission's denial of benefits in this case, and I think that happened early in April, so I bring that up because if there are no further appeals of this case, that's going to become a final holding. Okay? All right. So moving on to David Clark versus the City of Peoria. This is one of those firefighter presumption cases that we talked about last year, right around this time last year, Simpson and Johnston. Remember the firefighter presumption cases, right? If you're a firefighter and you've been working as a firefighter for 5 years, right, there's a whole list of conditions that it is presumed are causally related to your employment. The real important thing about the Clark case is that the commission applies that firefighter presumption retroactively. Okay, what do I mean by that? So the firefighter presumption was put into the law. The section that placed that into the law became effective on January 1, 2008. And you can see that Mr. Clark had his heart attack just a few days before that law became effective, January 1, 2008. But what the commission tells us in the Clark case is that that presumption applies retroactively. And the reason it applies retroactively to Mr. Clark, even though his date of accident was prior to the effective date of the presumption, is that a presumption is a procedural matter, right? Because it's an evidentiary matter. It's not a substantive matter. And so when something is procedural only, okay, the commission reviewing the applicable case law says that a procedural matter can be applied retroactively, okay, as opposed to a substantive matter, a substantive change in the law that creates a substantive right or takes away a substantive right, that can only be applied prospectively, right? So here's the commission telling us that the firefighter presumption is alive and well, even for dates of injury that are before the January 1, 2008 effective date. So if you still have any old firefighter cases hanging around, you can apply the presumption retroactively to those cases. The other interesting part of this David Clark case is how the commission and the arbitrator applied the presumption, right? Because we remember by looking at the Johnston and Simpson cases that we talked about here, appellate court cases that we talked about here about a year or so ago, we remember that there was this idea of bursting the bubble of the presumption, right? You burst the bubble of the presumption goes away, and therefore the petitioner is left without any benefit of the presumption. There's no like shadow or penumbra of the presumption that exists after it's been burst, right? So in this particular case, the arbitrator said, look, the presumption was enough in this case, right? The presumption was enough that the respondent never burst the bubble of the presumption, even though there was some expert testimony from the respondent's expert, Dr. Fintel, by the way, who was the respondent's expert in Johnston and Simpson, right? In this particular case, the arbitrator said Dr. Fintel's testimony did not burst the bubble of the presumption that was established by the section of the law that was applied retroactively to Mr. Clark, right? The commission says, yeah, we agree up to the point, Mr. Arbitrator, where you said that the bubble was not burst, right? The presumption was not burst. So this is a case where the commission decides that it's compensable, even though, just like in Johnston and Simpson, which were not compensable cases, right? Ultimately were not compensable, the presumption was burst, right? The bubble was burst. Why? Because the petitioner's testimony and evidence, including evidence from a Dr. Litow, L-I-T-O-W, who was the petitioner's expert in this case, that was strong enough that even after the presumption was gone, the bubble had been burst, right, that the petitioner prevailed in his regular, preponderance of the evidence burden of proof, right? He didn't need the presumption because his evidence was strong enough even after the presumption had been burst. But maybe it wasn't so strong that it didn't mean that they reduced the award from 25% as a whole to 20% as a whole, but I guess I'm nitpicking that, right? So, the idea is that there's a way to prove these cases even when the presumption has been negated and the bubble has been burst, right? You can prove it the old-fashioned way, right? By just proving your case. All right? Any questions about this? Any allergies anybody can draw about this retroactive, prospective, application? Yeah, Mark.
Yeah, I think it's just a rule of statutory construction because the legislature could provide that a procedural change is only going to be applied prospectively. So I think in the absence of any indication from the legislature, you would apply the procedural change retroactively, but it's just interpretation.
So Mark's got a good point, right? It's a rule of statutory construction, right? That if it's a procedural matter, it gets applied retroactively, whereas it's a substantive matter, it gets applied prospectively. More often than not, you'll see the legislature being really careful about this, right? Because, and they didn't do it in this particular case with the presumption, but more often than not, you'll see them being really careful about it. Because there's two kinds of important dates, right? There's the effective date of the change, which it was in that case, January 1, 2008, and then there's this applicability date, right? Which we've seen in recent changes to the Act, right? 2005 and 2011, right? Where it says the effective date might be such and such a date, right? But right in the provision of the statute, it's going to say this change applies to injuries that happen after, right? Remember the dates, right? September 1, right? Remember that? February 1, 2006, right? Those were the important dates, right? So it's kind of a two-level thing, right? The legislature can say this is the effective date, right? But they can also say, despite the effective date, it applies to cases where the injuries happen after such and such a date, right? And more often than not, they're real careful about doing both of those things. Okay, so let's talk about the Roy Sims versus Aramark case. And this, to me, is an important case because it's an indication of how the commission decides to use the 5 factors in section 8.1E, right? So we've talked these factors to death. We all know what the 5 factors are. And what I tried to do by putting this slide in kind of this 2-part way is so that you could make an easy comparison between the arbitrator's decision and the commission decision. So let's take a look at those things, right? So the ANA, there was a 12% lower extremity ANA rating. In this case, the arbitrator gave that some weight, and the commission said, yeah, we give that some weight too, okay? The petitioner, the occupation for this petitioner was a school custodian, right, which I suppose means that it's a bit of a heavier kind of job, certainly heavier than a lawyer, right? Arbitrator gives that greater weight, right? And of course, the commission affirms that part. Petitioner was 69 years old, limited, arbitrator says that means the petitioner had a limited work life, which means I suppose that those symptoms are going to be like compressed into this, limited work life, and therefore maybe more intense or something, and gave that greater weight. The commission affirms that part of it too. The evidence of disability corroborated by the treating medical records, even though the arbitrator refers to the IMEs, which aren't necessarily treating medical records, gave that significant weight, and the commission agreed with that, right? Where did the commission not agree with the arbitrator? Which of the 5 factors? The factor involving future earnings, right? Because what the arbitrator said was, look, there's evidence that this petitioner returned to his regular job, right? Returned to work full duty. Therefore, there's no evidence about how this is affecting his future earning capacity, and therefore, the arbitrator gave that factor no weight whatsoever. The commission, on the other hand, as far as I can tell, for the first time, using this kind of an analysis, and maybe you've seen it before from arbitrators or from the commissioner, says, wait a second. A return to work full duty is evidence of what that petitioner's future earning capacity could be, right? Because it means that the injury did not have any negative impact on that petitioner's future earning capacity, right? And therefore, the commission said that that should have been given some weight, because the fact that the petitioner returned to work is in fact evidence of what his future earning capacity is, because he doesn't have any negative impact on his future earning capacity. So that should have been given some weight as opposed to no weight at all by the arbitrator. Did it make a difference? Yeah, you look at the difference it makes, right? The arbitrator awarded 42.5% loss of use of the foot, and the commission reduced that to 35%, as far as I can tell, on the basis of a different analysis of that one factor only. Okay? All right? Any questions about that one? All right? Has anybody seen this? Has anybody seen this kind of language where it says, there's a return to work, full duty, therefore that means, future earning capacity is not in any way negatively impaired or something? Okay, so maybe this is the first time we're seeing something like this. So keep your eye on it because it might be important. All right, so the next couple of cases that we're going to get into are employer-employee relationship cases. And these are interesting, not necessarily because of the because of the facts or because of how they turned out, but because of the analysis that the commission gives us in these cases, right? So in this particular case, the commission affirmed and adopted the arbitrator's denial of employer-employee relationship, right? The commission says that the arbitrator was right to find that there was no employer-employee relationship with this case, but disagreed maybe a little bit on the rationale that the arbitrator had used, right? Because what the arbitrator had said was that this petitioner, in this case, was a partner, or I'm sorry, was an independent contractor to the employer, right? But what the commission says is no, that really what this petitioner was acting as is a partner, right? And if you look at section 320 of the Workers' Compensation Act, right, it says that partners, right, partners who exclude themselves from coverage under the Act are not employees, right? So if you're a partner in a business, right, as some of us lawyers are, right, you can exclude yourself from coverage. And I suppose not having workers' compensation insurance, because you can see that the Injured Worker Benefit Fund was named in this case, I suppose not having workers' compensation insurance is an indicator of you excluding yourself from coverage. Although I might disagree with that, right? I think in my opinion, it takes more of an affirmative act than that, right? It takes you going to an insurance broker and saying, I'd like to purchase coverage for my company, but I'd like to exclude myself from the coverage, okay? It was apparent here that this Rivera company had no coverage at all because the Injured Worker Benefit Fund was brought into the case. So this wasn't one of those ones where, you know, the petitioner was able, or the respondent was able to show a certificate of insurance that said everybody else is covered, but we're excluding the partners, right? Everybody's seen those, right? The certificates of insurance that have these, what's it called? Rider, right? A rider attached that says the following partners are excluded from coverage, right? Or we've seen in cases where it says, you know, this does not apply to Indiana, right? Or Illinois, you know, the other way around, right? So this rider. I don't think there was any evidence in this case that Mr. Scanlon had ever, you know, affirmatively decided to exclude himself from coverage, okay? Good news for the petitioner here is, as far as I can tell, this case was reversed and remanded by the circuit court just a couple weeks or so ago, right? Okay. So I'm getting a thumbs up that is in fact the case, and it's because the circuit court said he is an employee, or we need more information, or what? Okay. So Mike tells me that the circuit court in this case has manifest weight of the evidence standard.
The commission found that he was not an independent contractor, so that gets picked up to manifest weight of the evidence. So that finding was manifest weight of the evidence. And there was no evidence that Mr. Scanlon shared in profit, an essential part of ownership partnership with joint venture.
So this case is now coming back on the issue of employer-employee. Here's another employer-employee case where it's a more standard kind of thing, right? This is a truck driver who is working for a trucking company. In this particular case, the commission actually finds that the petitioner was an employee, even though the arbitrator had found no employer-employee relationship. And what's really important about this case is the analysis that the commission goes through, right? They talk about the Roberson case, which is still, at least from in the commission's point of view, probably the most important employer-employee case. It's an Illinois Supreme Court case that sets out the various factors that need to be analyzed in determining whether somebody's an employee as opposed to an independent contractor. And again, this test that we've talked about from time to time, this nature of the work test, right? So a trucker who is working for a trucking company is engaged in the nature of the work of his company, and therefore is more likely than not to be an employee as opposed to an independent contractor. So it's a pretty quick and easy way to kind of give a first blush at whether a worker is an employee or an independent contractor, right? Look at it from this nature of the business test first of all. If you cross that threshold, some of these other factors become important, but nature of the business is probably, at least, kind of the overall test for these kinds of situations, okay? Anybody have any questions, concerns? Want to talk any more about that one? All right. So let's move on to Catherine Berger versus the State of Illinois, the Department of Commerce and Economic Opportunity. So Interesting thing about this case is that it happens here, I mean, probably just a few feet outside that door, right? So, in this particular case, the commission affirmed the arbitrator's denial of benefits, so no compensation for this particular petitioner, and this is pretty clearly not arising out of case, even though there might have been a little bit of a wrinkle about the in the course of the case. So this petitioner falls in the atrium just outside here. There's some testimony about what was on the floor at the time that she slipped and fell. There was some testimony about there being a cone, one of these kind of yellow safety cones just a few feet away from where she fell. But at the end of the day, this petitioner was not really able to identify on what she fell, right? She wasn't able to say if it was water. She thought it might have been wet, but she didn't remember being wet when she got up or anything like that. So what she actually fell on becomes really important in the case. But before you even get to that, right, there's the in the course of problem that you have to deal with, because this petitioner was on her break, right? Personal comfort doctrine, John, right? So this petitioner's on her break, right? And what she says is that when she's on her break, not only is she allowed to, but she's encouraged by the state of Illinois, her employer, to get up and walk around, right? You know, move a little bit, right? So for all of you state employees, know that your employer encourages you to do that, right? So, on the basis of that testimony, right? On the basis of that testimony, she's considered to be in the course of her employment, right? Because she's on her break, doing something that she is allowed to do, maybe even encouraged to do, and even if she wasn't allowed or encouraged, maybe it falls under the personal comfort doctrine anyway, right? So that's what she was doing in the atrium instead of up on the 6th floor or wherever the Department of Commerce and Economic Opportunity is, right? So what this case ends up being then is an arising out case, right? And because this petitioner was not able to identify what was on the floor, right, what she slipped and fell on, because she wasn't able to specifically identify it, all right, the commission and the arbitrator held that there was no arising out of because she didn't know what she fell on, right? Was there a neutral risk analysis done here? I don't know. I mean, I don't know. But what could the neutral risk analysis have done for her anyway, right? Quantitatively, yeah, I go by that spot when I'm leaving, and I go by that spot when I'm coming back. Is close enough? You know, I don't know, maybe not. Under the quantitative analysis, qualitative analysis, what would that be here? You know, that floor out there, even though it's not wet, is more slippery than other floors or something. I don't know. I don't know how this could have been turned from, you know, how a qualitative analysis could have turned this into an employment risk. Okay, let's see if we can expand this a little bit, okay? Would it have mattered what was on that floor if she was able to identify it? Okay, would it have mattered? Anybody want to take a shot at that one, right? If she said it was water on the floor. Okay, so the arbitrator brings up a good point, right? Okay, so let's say she said, I looked up and I saw that there was a hole in the massive, you know, glass dome, and there was rainwater dripping right where I fell, and that I know that's what caused me to fall. Okay, is that compensable under those circumstances? Okay, so you say yes. Why?
Well, the part is responsible for maintaining the premises. She's within the personal comfort doctrine. You also have to still be on the premises. State of Illinois.
So the idea that it's the employer's premises becomes really important, right? The employer's premises becomes really important, right? Because she's on the employer's premises, right? But everybody, I hope, by now, because I've been beating a dead horse for these many months, remembers Dukich, right? The case that we've talked about over and over again now, right? Rainwater. Is it a problem that it was rainwater? Okay. Is it a problem that it might have been rainwater tracked in from other customers in the Burger King, right? What about if it was a natural accumulation of ice and snow up on that window that was melting and dripping down onto that spot, right? Does the Sheriff Smith case apply because it's not an unnatural accumulation, okay? And does the famous question, at least it's famous and infamous in my mind, right, of one of our justices, what could the employer have done differently, right, to prevent this accident from happening? Does that figure in at all? Okay. What about Ms. Berger's so-called comparative fault, right? What if it was a giant puddle of rainwater, and she said, you know, I'm not walking around this thing. I don't want to walk 10 more steps. I'm walking right through that thing, right? And same injury happens, right? Does that make a difference, right? So these are all issues that I think we're going to have to be struggling with, you know, as the months and years go by. But I think some recent cases that we have seen bring up these issues were, frankly, as an older lawyer, you know, I never had to think about issues like that previously. You know, if you fell at work, it was a pretty good shot that you were going to, you know, that it was going to be compensable, right? Because you were on your employer's premises, right? There was something about either your work or your, you know, about the condition of the employer's premises that caused you to fall, right? What if Ms. Berger said, oh my gosh, it took so long to get a cup of coffee at Dunkin' Donuts that I was rushed. I was about ready to blow my break time, and I had to rush back to get to I was rushing, right? Would that have been enough to make this a compensable case? So, good luck to you all. Any other comments or questions about this? Okay. So Elaine Theobald is the case that I talked about earlier, right? So she actually worked for Rockford Mass Transit, right? So this is a case where the petitioner gets benefits, right? The arbitrator awards benefits, the commission affirms and adopts the award of benefits. Here's the petitioner's situation in this case, right? She's a bus driver. You know, that, like I said, that route sign on the front of the bus. Every so often, she has to get up out of her seat, reach up, push the button so that it goes, you know, so now showing the reverse route, right? Right? When she gets to the end of the route, she's got to change it. One time when she gets up out of her seat to push the button, pop in the shoulder, right? Ends up being a compensable case, right? What's the analysis here? What's the analysis? The analysis is employment-related risk, right? The arbitrator finds that the act of reaching upward from the driver's seat of a bus to change the head sign is a risk associated with the employment. Cites the Young case, right? Young, we've already talked about. This is the guy reaching into the box to take the part out of the box, right? The arbitrator finds that the act of reaching upward from the driver's seat of a bus to change the head sign is a risk associated with employment, okay? What about this everyday occurrence idea, right? How does the everyday occurrence part fit into this analysis of what an employment-related risk is? I don't see that phrase or those kinds of words appearing in this particular decision, all right? The record showed that she was injured performing her job, right? And I suppose that Ms. Deidre Kaler, who we talked about at the very beginning, said, yeah, but I was too, right? But I was too. What's the difference here, all right? Is it the height that she has to reach up to? Okay, is it the confined space that she might be in? Is it that she's short of stature? You know, but those seem to me to be things that would go to a neutral risk analysis, right, as opposed to an employment risk analysis. When the commission affirming and adopting the arbitrator says, no, this is something she had to do to perform her job. I don't think it matters that she was 7 feet tall, right? Right? It wouldn't matter if it's an employment-related risk. I think those other kinds of things are neutral risk analysis. Okay? Any questions, concerns? Anybody want to try and distinguish these cases? You know? Okay. Yes?
If she was a secretary and part of her job was to reach up to get a file, she had to reach up to get the file. She did that 8 times a day.
Okay, so the next question is, you know, a secretary reaching up or an assistant reaching up to get a file, right? Has to do it 8 times a day, right? Is it an employment risk or is it a neutral risk, right? Because when you talk about 8 times a day, right, that I think is a neutral quantitative analysis, right? It's not, it's right. What if she has to do it to perform her job? What does it matter that she has to do it 1 time a day or 8 times a day, right? If she has to do it to perform her job, how many times she does it shouldn't make a difference. And clearly that's how the commission analyzed this risk for Elaine Theobald, right? They said she has to do this to perform her job, right? Therefore, it's an employment-related risk. And again, I can just, in my mind's ear or whatever, in my mind I can hear Deidre Kaler saying, yeah, me too, right? Me too. So, Hartwell is an important case, I think, and then we'll be done. Hartwell is an important case, I think, because it talks about what you end up having to prove after you've already proven a 19B, right? So this is a case where petitioner tries a 19B, wins it, right? Comes back after having won the 19B for additional TTD and additional permanency, right? And basically the petitioner's case here is, hey, look, I've already won this case once, right? The law of the case is that I won, right? Res judicata, estoppel, whatever words you want to put on that, right? I've already won this case, right? Therefore, give me my money, right? And what the commission reminds us in this case is that it's not that simple, right? Even after you come back after a successful 19B, where you've proven accident, where you've proven causal connection, where you've proven all of those things that you needed to prove to get an award, right? Even after that, it's the petitioner's burden of proof to always prove causal connection to the current disability, right? Not what the disability was back at the time of the 19B, right? You can't just rest on your laurels and say, I've already won this case. As petitioners, you can't just rest on your laurels and say, I've already won this case, right? You've got to prove that the current disability, whether that's TTD here, as you can see, there's an adjustment in the TTD that was awarded to this petitioner, and the permanency, right, is related to the accident, right? To all causal connection as it relates to the current disability must always be proven, no matter how many 19Bs you've previously won. Okay? Any questions about that? Any concerns? Comments? All right, well, I'm too tired to go on, so.